Good morning, everyone. My name is Matt Scully. I am a partner with Burr I am based in Birmingham. I've been with the firm many years. I help clients out with all things employment related, investigations, lawsuits, EEOC charges, everything across the whole spectrum of employment related advice. I also have Bailey Woods presenting with me today. He's an associate in our office. He also supports our team with anything employment related. And today we are going to be talking about a year in review. We always find these year in reviews helpful, and there's a really good turnout today. Our focus is on federal actions. It's not state specific. So this would include new laws passed by Congress, regulations issued by any applicable agencies, executive orders issued by the president, and guidance and enforcement from the various federal agencies. The point of this presentation is to flag items you may have missed or items you may have forgotten about. The good news is there's not much to cover. There has not been any substantial changes in the law or what we would call landmark changes. So if you saw this year in review and it made you nervous because you were worried that you missed things, you haven't missed much. But there is a few important changes, particularly depending on the type of employer you are, that could have substantial change, and we're going to cover all of those today. All right. For our first slide, I want to talk about what's called Project Firewall. And this just came out a couple weeks ago, and this is a formal partnership between the DOL and the EEOC. It intensifies enforcement of misuse of H-1B program and national origin discrimination with a focus on disadvantage to American workers. The partnership is directly with the DOL and EEOC, but it also coordinates with the Department of Justice, the EEOC as noted, and the U.S. Citizenship and Immigration Services. And they will share information and refer cases. And essentially, it uses the enforcement authority of all those agencies to take actions consistent with the goal of Project Firewall. Many of you know the H-1B visa program allows employers to temporarily hire foreign workers for specialty occupations, but that is a primary focus of this Project Firewall. It expands enforcement consequences. That's back wage liability, civil money penalties, and debarment from future access to the H-1B program. What this means in practice is tighter enforcement. We would expect more I-9 audits. We would expect more surprise site visits, and we would expect more attention from the EEOC. So, for example, if an employee comes to the EEOC with a concern that they've been discriminated against based on national origin, and if this is an American citizen, this will be a priority for the EEOC and something that will have more attention than it otherwise would have. What are some high-risk areas for employers? If you use H-1B visa workers, obviously you're going to be at risk here. This could come up in your recruiting, your job postings, where you employ individuals, how you employ individuals, how you pay them, what other non-H-1B visa workers perceive of those workers, and whether they could think something was done for an improper reason and go to the EEOC. We recommend everyone who uses H-1B visa workers to conduct internal I-9 audits, train your facility on what to do if an investigation group shows up for an on-site visit. Look at your recruiting material, job postings, anything like that for keywords or words that could trigger someone to think that you're engaging in national origin discrimination. And also analyze how you're paying these H-1B workers and that you're keeping accurate records. The next part we're going to talk about is AI. There has been increased focus on AI. We've seen the clients we represent use it more. We've been using it more in our practice. AI in the employer and the hiring HR world typically comes up with hiring and screening employees, but it also can come up in creation of job descriptions or compensation modeling or reduction in force analytics. A main component of AI is disparate impact. The theory is that AI is a software system. It's generally not going to intentionally discriminate, but the recommendations it makes to you, the practices it suggests to implement, could have a disparate impact. And disparate impact is a theory that when you did not act with intentional discrimination, the tests, the policies, the practices you used had a disparate impact on a certain class of employees. And AI tools can violate Title I if they cause lower selection rates for a protected group, unless you can show it's job related, consistent with business necessity, and there's no less discriminatory alternative. So an example of that would be if you used AI to screen certain resumes you receive. And because of that AI tool you're using, it had a disparate impact on, for example, African Americans. It was screening out more African American applicants than others, and it was doing it at a statistically significant basis. This could cause a disparate impact claim. It wouldn't be because you were intentionally doing this. You were not intentionally discriminating against anyone, but your use of AI had that impact of discriminating against people. And then you would have to justify your tools as consistent with business necessity and that there are no less discriminatory alternatives, which is a high standard to prove. You are responsible for actions taken by your vendors. So if you outsource this to a vendor or you ask a vendor to do this for you, they will have to make sure their tools are not having disparate impact. And them simply telling you their tools are not is not going to be enough. What we recommend that everyone do is self-analyze. Monitor how your systems are impacting applicants. We recommend having an AI policy. If you are going to use AI in any of your employment functions, have a policy on how it's going to work. Conduct audits on the impact. And if you engage with legal counsel on this, it can be protected from disclosure. What that means is if you do an AI audit and you do find there are problems, but you involve an attorney, it can be what's called attorney-client privilege or attorney work product, and it may not be discoverable if there ever is litigation. So that can be an opportunity to figure out you have a problem. It would still be protected from disclosure to someone who may want to sue you or the government, and then you can take appropriate steps to correct any issues. We also recommend that you look at vendor agreements and make sure that those address this issue. If they're going to use AI, what steps they've taken, and your opportunity to get information from them and access to their data so you can understand if there's an impact. The EEO guidance on this issue says that employers should provide job applicants and employees who undergo assessment by an AI tool with as much information as possible, and it gives them examples to use. What matters here, because this is an update for 2025, the EEOC removed its AI-related guidance from its website. So when President Trump was elected, he rescinded an executive order from Joe Biden, which had directed federal agencies to use regulatory and enforcement tools to address discrimination concerns related to AI use. That executive order was rescinded, and as part of that, the EEOC removed its AI guidance. So the guidance the EEOC had put out is now outdated or not reflective of current policies. However, that does not change federal anti-discrimination laws. So if you have a policy or practice that causes a disparate impact, there are federal laws that apply, and federal courts will apply those laws. So it doesn't have to be AI specific, but those laws can be used for AI programs. Next topic we're going to cover is neurodiversity in the workplace. This is not necessarily a new issue, but it has gathered more attention recently. Neurodiversity generally encompasses brain processes. It can be ADHD, dyslexia, PTSD, a whole spectrum of conditions. There's a more common use phrase called neurodiversity. And we've seen, and the EEOC records reflect, a significant increase in claims based on this. What does this mean for employers? This is not a new legal concept. This is a concept that you have to accommodate employees who have disabilities. So if the individual's mental state or neurological processes would constitute a disability under the Americans with Disabilities Act, then you must engage in the interactive process if they ask for an accommodation, for example. You must provide reasonable accommodations if they ask for modifications to the workplace. So your process does not necessarily change. It's the same steps for dealing with accommodations made under the ADA. But no, this is an issue that's out there, and some employers don't give neurological issues the same concern or attention that they would an obvious medical condition that it's clear the person needs an accommodation. So we want you to be careful and not to dismiss requests for work modifications under this neurodiversity thought process, and understand these types of requests could be covered under the ADA.
Great. So as Matt mentioned, we're also going to talk about some of the executive orders. There have been, over the course of this year, a number of executive orders relevant to employment issues, particularly discrimination and DEI. For example, Executive Order 14281 announced Trump's preferred policy to eliminate disparate impact liability. I believe we touched on this before. The liability imposed on an employer's neutral criteria has a disproportionate impact on a particular protected class. This aim was announced in Project 2025 as well. I think we touched on it on a previous morning show. But we've not seen much movement on this issue since this order. Now, there have been some other orders, 14151 and 14173, that terminate federal DEI programs, require federal contractors to end their DEI efforts. These orders also encourage non-federally funded employers to bring an end to their DEI efforts as well. And the EEOC has released some guidance on DEI programs too. So jumping kind of to the EEOC, President Trump instructed all agencies to, quote, combat illegal private sector DEI preferences, mandates, policies, programs, and activities. In January, he fired 2 Democrat-appointed EEOC commissioners, ending the Democratic majority. And then in March, the EEOC and DOJ released technical assistance documents regarding these unlawful DEI programs in the workplace. And then just a few weeks ago, President Trump nominated a company defense attorney to serve as the EEOC's new general counsel. So now we will dig in a little bit into DEI programs and what would make them unlawful. So the EEOC may view certain programs to constitute disparate treatment, which is discrimination directly based on an individual's protected characteristic. This would include discrimination in any term or condition of employment. We've listed a ton of them here: hiring, firing, promotion, pay, benefits, all those. Let you guys kind of take a look at that. But that's not the only, it's not the only way the DEI programs can be found unlawful. There's another area of concern the EEOC has identified, would include unlawful segregating or classification of workers based on protected classes. This would include limiting membership in a workplace group, like an affinity group, to certain protected classes. Only this group of people can come into this workplace group, can attend this meeting, can discuss this issue. The EEOC is going to look critically at those types of programs. There's also the issue of harassment. This can come up in employers' DEI programs. An employee may argue that there's a hostile work environment that's created by a training program. This will be based on the content, the materials provided in the DEI training. So employers should be cautious when you're creating these programs. Just ensure that you remain neutral when discussing different protected classifications, so you don't have an employee claim that, this hostile work environment has ensued following this training. And then lastly, on these DEI programs, employees objecting may have protection against retaliation. For example, if an employee has a reasonable belief that a DEI program violates federal law in ways that we just discussed, and that employee then makes a complaint or refuses to participate, employers could face liability for retaliation should the employer take any adverse action against that employee. But that is it for DEI. And we will jump to kind of some wage and hour issues now, starting with the paid program. This program was launched in 2018 during Trump's first term. It was pretty popular. It went away during the Biden administration, but it is back. This program allows certain employers to self-report possible violations of the FLSA or FMLA to the Department of Labor. If the DOL finds a violation, damages are limited. That's the big draw. The employer will just have to pay back pay or whatever remedy is owed for that particular violation, but there's no other expenses like liquidated damages or attorney's fees that'll pop up. So we'll kind of talk about that process a little bit. It starts with an employer conducting a self-audit to identify any potential violations. So once that's completed, the employer will then contact the DOL's wage and hour division to discuss their findings, the employer's findings, that is, and kind of the scope of the possible violations that the employer has identified. The wage and hour division will review and let the employer know kind of their findings too, if they agree, are there violations, what those damages are, and then how it's best to kind of confront those damages. And then within, I believe it's 15 days, the employer will just pay those damages and slate's wiped clean. The program does have some particular eligibility criteria, though, that I've listed here. Employers can't have been found liable for an FLSA or FMLA violation in the last 3 years. The employer cannot be a party to any litigation asserting the same violation that the employer identified in the self-audit. The Department of Labor cannot be actively investigating the identified violations, and the employer can't have participated in the paid program in the last 3 years.
I'm going to talk briefly about what's called the Big Beautiful Bill. This deals with tax stuff, so disclaimer, I don't fully understand a lot of this stuff. I'm not smart enough to get it, but we have tax people who can help you answer these questions if you have them. But to summarize, there are changes to how taxes are treated for overtime and tips. So employees in occupations where tips are customary, like servers and bartenders, employer may deduct up to $25,000 in tips. And this second part probably applies more to the employers on this call. Employees receiving overtime pay under the FLSA may deduct up to $12,500 of the premium portion of their overtime pay. And of course, the premium portion is that 0.5 that would be owed to employees for the overtime. These provisions reduce federal income tax only. They don't apply to FICA or Medicare. Employers should be prepared to track qualified overtime premiums, including if it's an occupation that customary receives tips. The second part of that is an extension of the business credit for paid family and medical leave. So this tax credit is available for payments made to employees making less than $96,000 who are receiving paid family and medical leave available under a qualifying company plan. There are a number of other programs that benefit employees and employers from a tax perspective. That includes child care credit, dependent care assistance, student loan repayment, and there's other ones out there. So be sure that your team understands that there are potential benefits for you and employees, and we certainly have someone at Burr who can help answer any questions you may have about that. Independent contractor guidance. So for those of you who use independent contractors, this is important. There has been a yo-yo back and forth within the wage and hour division over the independent contractor test. And there are a lot of independent contractor tests that apply to different laws. Wage and hour division obviously will apply to wage and hour issues, and misclassification of an employee could lead to exposure for minimum wage, for overtime, and while the IRS has its own tax, it could lead to tax consequences. The first Trump administration in 2021 introduced a streamlined factor that was more favorable to finding contractors. That rule was rescinded under the Biden administration, and Biden introduced a multi-factor economic reality test that made it more difficult to classify workers as contractors. Well, we're back again to the initial wage and hour division guidance. Right now, the instruction is for the enforcement agents not to apply the 2024 Biden era final rule. And so presumably the wage and hour division has reverted back to its original guidance. Again, this is guidance from the wage and hour division. Federal courts interpret the regulations as they see fit with some level of deference to the wage and hour division's opinion. But ultimately, when you litigate these issues, you're going to be more times than not in a federal court deciding them. So while this guidance is helpful, particularly if wage and hour division is investigating you, ultimately some of these issues will be decided by court. But what this means generally is that it's effectively easier to classify workers as independent contractors. And this doesn't mean you can call someone who's clearly an employed independent contractor, but it means using these factors, it's more likely that we can justify someone being classified as a contractor. And the key aspects that are going to be looked at is the work integral part of the business? So is it a core of what you do, or is it an ancillary function or a support function? The permanency of the relationship. Is this a temporary assignment, 3 months, 6 months, or is this expected to be a long-term relationship? The worker's investment. Are they bringing equipment? Are they bringing materials? And the degree of control they exercise. Are they going to solve the problem themselves, or do you give them very specific steps to follow? And can they make a profit or loss? Oftentimes this comes up in flat fee arrangements. We need this project done, and here's a fee we're going to pay you. And depending on how quickly or effectively the contractor gets the work done, they can make money, or if they're ineffective, or if they need to bring in outside support, for example, they may lose money. So that's going to be a factor that'll be considered. And all of those will be put together, weighed. No one factor is dispositive. They'll be weighed together, and they'll make a determination whether someone's properly classified as an independent contractor. Note, just because someone's temporary or part-time, that's not a reason to make them an independent contractor. You're going to have to apply these factors above.
And so now we will turn to the OSHA side of things. Fortunately for me, there have been no new OSHRC cases since the commission lost its quorum in 2023, so there's nothing for me to summarize there. The agency has remained active in some other ways, though. One recent example is the National Emphasis Program on Amputations in Manufacturing Industries. This created an increased focus for inspecting manufacturing plants for violations likely to cause amputations or other serious injuries, such as machine guarding or lockout tagout and some other areas of violations. We have some administration priorities. We've seen some of these take effect. Similar to the paid program that we talked about on the wage and hour side, we've seen an increased focus on compliance assistance. And given the government shutdown and the reduced number of inspectors, we do expect, like we predicted, to see the final tally of OSHA inspections to be a good bit lower than in previous years. There is the Seventh Circuit decision that we'd like to discuss a little bit, affirming a criminal conviction against a company's officers for an explosion on site. At that site, one officer directed the falsifications of readings and logs, and another officer was omitting that from compliance certifications. So everyone there is just doing a great job all around, and now they've got prison time. So just warning, be a little cautious. And then one more thing on OSHA is we've seen some changes to the field operations manual with some major penalty reduction opportunities. These include a 70% penalty reduction for small businesses, that is businesses with 25 or fewer employees. There's a 15% penalty reduction for employers that promptly fix hazards identified during inspections, and a 20% reduction for employers that haven't been inspected before or have been inspected in the last 5 years but didn't have any serious, willful, repeat, or failure to abate violations. So an opportunity for kind of a decreased payment there.
Yeah. This is the last section. We're going to do briefly a labor update. similar to what's happening with OSHA, we do not have a quorum with the National Labor Relations Board. And the National Labor Relations Board is a quasi-judicial body that decides cases under the National Labor Relations Act. So they effectively set the law for employers to follow under the National Labor Relations Act. Of course, that's subject to court review, but it's a very important agency for anyone dealing with anything union related and beyond, because there's certainly a lot of conduct not union related that can fall under the purview of the board. But right now there's not a quorum. The Senate has not confirmed enough members for there to constitute a body that can issue new decisions. Typically, there's going to be 5 board members, and to have quorum, you need 3. And we currently do not have a sufficient number of members to have a quorum. So what that means is a lot of the anticipated changes we expected to see from the NLRB have not gone into effect. But once a quorum is in place, we would expect there to be changes on these issues. One of them is bargaining orders. If there are unfair labor practices occurring in the election period after election petition's been filed, there's restrictions on employee speech during about unionization. There's captive audience meetings, and those are meetings that are required for employees to attend, in which employers can give information about unionization. In that Amazon case, those were found as potentially unlawful. There is a stair cycle decision that's very important for anybody who has work rules, which I hope you all do. I hope you have a handbook with work rules. It creates a very high burden for showing that work rules are lawful. And if you haven't had someone look at your handbook recently, it may be time for a review to make sure it's compliant with the stair cycle guidance. And then finally, in the Atlanta Opera Inc. case, there's a new standard for making it easier to classify workers as employees. What has happened is Trump has been able to appoint a acting general counsel, and the acting general counsel has rescinded numerous memos issued by the Biden general counsel. These have to do with employee surveillance, when's that unlawful, the expansion of remedies. Under the Biden administration, there was a very expansive view of the remedies available for violations. Those have been rescinded back to what we would call how it had been before and normally is. There's been changes to when injunctive relief's inappropriate, and confidentiality and non-disparagement provisions, particularly as they pertain to settlement agreements, which is very important for all employers to know. Local regional activity. So as most of you know, the Volkswagen workers voted to have the UAW represent them. This was in April 2024. They've been bargaining since then, so well over a year. Volkswagen made what they called a final offer on September 17th. The UAW made a counter proposal. The parties have not been able to reach an agreement, and the UAW has now authorized a strike, and this happened October 28th, 29th. Strike hasn't happened yet, but that gives you an indication of the tensions here. We are all watching this closely. The strike will certainly have ramifications throughout the Southeast and the automotive industry, but if an agreement is reached, it certainly will have ramifications as well. We would expect any agreement reached between the UAW and Volkswagen to be used in future organizing campaigns, and would expect increased union organizing activity after any agreement is reached. UAW won a preliminary victory in the very large Bosque battery plant in Kentucky. However, it was a very close election, and there are 41 challenge ballots, so the outcome has not been certified. More recently, the UAW lost, or closer to home, the UAW lost an election up in Huntsville with International Motors, and at Mercedes here in Alabama, we have seen increased union organizing activity. That is it. That is the update for the year. For the federal landscape, of course, consider the state you operate in, and there may be some changes locally to consider. But we hope that was helpful. If you have any questions, you can send some comments to us. You can email us directly, but we appreciate everyone's time.